Good morning, ladies and gentlemen. Thanks for joining our tax webinar. Today we have very interesting content for you, and we hope that you will find it very helpful. During the webinar, I will speak together with my colleagues. With Maria Kabanova, Senior Associate of Tax Practice, and Maxim Gubanov, who is also a Senior Associate in Commercial Practice. You see that the topic of the webinar, it looks very ambitious. And of course, during 1 hour's webinar, it's impossible to cover all tax news for Q2 and Q3. And we don't have such a goal. But with colleagues, we decided to focus on the most interesting, the hottest topics, which are either already trends or will create the trend in the future. So as regards agenda for the webinar, it will include 3 blocks. The first one, practical aspects of double tax treaties application. Second one, requalification of intragroup floors, and the third one, intragroup services. Very important note, if you have any questions to either of the speakers, don't hesitate to wait till the end of the webinar, and please write down your questions to the chat. Once we will complete the webinar, we will look through the questions and we'll try to cover all of them. If not, we will be happy to speak to you personally after the webinar. So next slide. We will go forward to the first block, practical aspects of tax treaty application. And here I would like to start with a letter of Federal Tax Service dated 20 February 2021. This letter is addressed to both the taxpayers and to the tax authorities, and it's dedicated to the general aspects of double tax treaties application and check of justification of benefits available according to the double tax treaty. During the several past years, we see the trend for FATEAS that FATEAS permanently does the home task. What does it mean? From the one side, FATEAS analyzed the recent court practice. From the other side, it analyzed the local approaches of the local tax administration. FATEAS combines all this information and estimates the efficiency of tax audit procedures. And result of this home task is eventually the clarification letters, which looks like a guide that creates some specific matrix for certain tax cases. So let's say that this specific letter looks like a guide, and it covers the 3 most important topics for double tax treaties application. The first one, it dedicates to formalization of tax residency certificate. Second, confirmation of beneficial owner status. And third, the identification of status of the foreign recipient of income. What is important to note here is that the main message of the tax administration to the local tax authorities and to the taxpayers is that to refuse the formalistic approach. And FATEAS directly says that to the local tax authorities that if you have any questions, if you have lack of information, or you need to know more, please don't refuse automatically to the tax benefits refit, but instead please request additional documents and make your conclusions upon analysis of all these documents. Furthermore, I will talk about 2 cases, court cases, which demonstrates how the local subsidiaries, Russian subsidiaries, local companies could perform when they face with a tax dispute when involving the double tax treaties application. I think it's not a secret that during recent 5 years, the Russian tax authorities become more and more aggressive. And of course, since these are the Russian subsidiaries who are responsible for due taxation and calculation of Russian withholding taxes, Russian subsidiaries very often prefer to perform accurately, conservatively, and they do their own due diligence. And sometimes they decided to voluntarily recalculate withholding taxes, not awaiting the results of the tax audit. So we have two cases here to share with you. The first one is case Transbunker Vanina. This is purely a technical case. We have the Russian subsidiary and its Cyprus shareholder. And in this case, during the audit, the Russian subsidiary realized that Cyprus shareholder has a lot of criteria of conduit company, and it realized it thanks to scrutinizing analysis of the tax administration. And the subsidiary decided not to wait to the end of the audit, and it voluntarily recalculated of the tax. And the essence of the case was what exchange rate to apply for determination of the ruble equivalent of additional withholding tax on dividends. Taxpayer thought the exchange rate at the date of initial payment of this withholding tax should apply, but vice versa, the tax authorities noted that there is a general principle that every taxpayer or tax agent shall calculate ruble equivalent based on exchange rates actual at the date of payment of tax. So finally, the court ruled in favor of the tax authority, and for me it's obvious because the tax practice and the court practice on the issue is quite consistent. The second case, it's Kuchuk Sulfat case. Here we have also Russian subsidiary and Cyprus shareholder. Few words about the history of this structure. Till 2005, there was a subsidiary owned by the Russian shareholder. One day, the shareholder transferred shares to the Cypriot company, and the Russian subsidiary became having shareholder of the Cyprus company. So in order to apply a 5% reduced withholding tax rate, each year the taxpayer received tax residency certificate from the shareholder first, and second, it received the legal opinion of the Cyprus auditors, where it was mentioned that all criteria stated by the Russian Cyprus double tax treaty are satisfied. So Russian subsidiary considered it's enough to justify reduced withholding tax application. But one day it had a tax audit, and during this audit he understood that there was something wrong with the share transfer. There were misleadings, and subsidiary was never aware of the details of such transaction and never asked about that. But now it realized that there is a significant risk of additional payments of recalculation of withholding tax. So it decided again not to wait till the end of the audit, and he calculated tax voluntarily. What is interesting in this case is that this is not a tax case. This is a non-tax dispute between the Russian shareholder and the Russian subsidiary and the Russian shareholder. And the subsidiary goes to court in order to claim its own expenses incurred for voluntary payment of additional withholding tax. And in this situation, Russian court supported Russian subsidiary, and it's ruled in favor of the Russian subsidiary. So next slide, and I pass words to my colleague Maria.
Okay, thank you, Yulia. Actually, there is one more topic that we wanted to highlight as part of this major block dedicated to application of the double taxation treaties. And this particular topic is not yet necessarily crystallized in the existing court practice. However, this is something that we frequently see in practice when dealing with our clients and the tax authorities on similar matters, and it concerns the application of the so-called look-through approach under the Russian law. As many of you probably know, this approach exists in the Russian law for several years already, and practically allows the Russian taxpayer to voluntarily indicate as the UBO of the passive income distributed from Russia, some company which is not its immediate shareholder or not its immediate recipient of the dividends. And well, this approach was quite helpful in cases when, for example, the Russian entity was controlled by some purely holding structure located in Cyprus or the Netherlands, which was not engaged in some sufficient economic activity. So in these cases, the taxpayer may claim that the real shareholder and the real UBO is located somewhere up the chain. However, what we see in practice is that the Russian tax authorities are still quite reluctant to allow the taxpayers to benefit from this approach. And we can split these cases into two major categories. The first one is when the UBO is located in Russia. Formally, the Russian law, under certain conditions, may allow application of a 0% rate to the dividends ultimately distributed to a Russian shareholder. However, first of all, the Russian law has been recently changed in this domain. So the possibility to apply the 0% rate under the look-through approach would be terminated starting from 2024. And in the interim period until 2024, it may only apply in a very limited nature, subject to fulfillment of rather formalistic criteria that you may see on the slide. I will not be stopping on every of these to save us time. However, I would like to highlight that one of these criteria is that the Russian shareholder should receive not less than 50% of the amount of dividends being distributed from Russia. And in practice, sometimes these conditions can hardly be met. For example, in case of a 50-50 GD, what we frequently see is that the foreign shareholder sometimes wants to get some disproportional part of the dividends simply to compensate the withholding tax rate applicable in Russia for his part of the dividends income. And in this case, formally, the Russian partner also loses the right to apply the 0% rate. So this is some areas that may need to be controlled when dealing with the Russian GB partners. And another side of the question, which may even be more important for the foreign structures, is that even in case when the double tax treaty with the jurisdiction where the UBO of the group, the Russian taxpayer is located, formally allows application of a reduced tax rate, Russian tax authorities try to seek to some formal grounds still to refuse it. And one of the most obvious examples exists under the Russia-France DTT, where the Russian tax authorities issued several explanations since the end of 2020, saying that, well, first of all, in order to apply the reduced rates under the Russia-France DTT, the dividends received from the Russian subsidiary should fall under the parent subsidiary regime, and this regime is not applicable in case of indirect participation. And secondly, the investments that are also should be made under the DTT in order to apply the reduced rate, such investments should be made directly by the UBO to the Russian company paying out the dividends, which is frequently just practically not possible when you have a chain of shareholding. And for example, the investments are pushed down to the Russian subsidiaries through this chain. So we might say that these existing explanations are a little bit too aggressive, and there is probably some floor for discussion and different qualification. But however, since they exist already, the taxpayer applies a look-through approach with France should be ready to stand its position in court and justify it additionally. This is not an exceptional case under the Russia-France DTT. I just gave this example because we know that a lot of our clients come from this jurisdiction. The final thing to say here is that the area of a particular control in our view is if the taxpayer wants to apply the look-through approach because its shareholder, its immediate shareholder, is located in some of the jurisdictions that Russia is now negotiating or changing the DTTs with, such as Cyprus, Malta, Luxembourg, or the Netherlands, where the DTT is even denunciated. Because we saw it in practice that some people were saying, okay, look, we will now claim that our UBO is located somewhere up the chain and we will start applying the DTT with them. And we must say that this is most probably a no-go unless you have a strong business case behind this. And even in this case, you should probably be considering and paying particular attention to the way you justify the UBO and the way you justify the application of the DTT rate, because this kind of operations will most probably be under the particular scrutiny of the Russian authorities. So thank you. Next slide. I'm passing the word back to Yulia.
Thank you, Maria. On this slide, I will talk to you about one more case. It's called Uralchem case. And this is a very good illustration to show that the structures like Russia, Cyprus, and on the top BVI or another jurisdiction which doesn't have double tax treaty with Russia, they do not work anymore. Russian tax authorities know very well such schemes, and very often they succeeded in recognition of intermediary companies, here it's Cyprus company, as not having the beneficial owner status. What is also interesting in this case? The Russian tax authorities, they opted to collect a lot of documents and information about the status of intermediary Cyprus companies, about BVI, about the management of these companies, and it means that they always scrutinize purely holding companies very carefully. And if you have in your group some purely holding companies without any parallel commercial activities, let's say, it means the companies which just hold the shares of subsidiaries and maybe are involved at the same time in the some cash pooling financial arrangements, you should take care every time, because for sure tax authority will ask you numerous questions during the tax audit. And to finalize our speech within the second block, I would like to talk briefly about the update of changes to the international double tax treaties. So what we have now? Now we have already the amended double tax treaty with Cyprus and Malta. Starting from the next year, we will have amended double tax treaty with Luxembourg, and unfortunately, we will not have a double tax treaty with Netherlands. What about the current works, which will continue next year? Firstly, the Russian government initiated communications in terms of amendment of the double tax treaty with Switzerland. There are no much news about that still, but the respective letter is already sent to Switzerland. Secondly, there is an idea and the further step after Switzerland to continue amendment of double tax treaties, and the next steps belongs to Hong Kong and Singapore. And the third and the final thing I would like to talk to is possible amendment of the Russian tax code, because of course upon denunciation of the double tax treaty with Netherlands, Minfin is continue thinking about that. It continues estimating the possible negative effect of this denunciation for the Russian business, who particularly has branches or subsidiaries in Netherlands. And Ministry of Finance have an idea maybe to insert some amendments to the local Russian legislation and to provide some support measures for the Russian business who suffered from double tax treaties amendments. So we are finished block 2, and I pass words to my colleague Maria, who will go to block.
Yes, thank you. Next slide, please. And within our second block, we would like to summarize some recent cases where the Russian tax authorities tried and requalified the nature of the operations. Actually, this is a trend which exists with us for several years already. So it looks like at some moments the tax authorities decided why dig into multiple technical details when we can just come and say that your transaction is fake or it did not meet its economic goal, and change the total tax treatment on this basis. And first, these cases were relatively rare. We mainly saw some examples of reclassification of the management fees into dividends and so on. But it looks like the tax authorities generally favor this concept and now use it for some other cases as well that we will now speak about. So the first case, which happened this spring, and it is still being reviewed by the Russian courts, so the next hearings being scheduled for this December, concerned the requalification of the know-how flow into the dividends. So the Russian taxpayer first deducted the royalties paid under the know-how license agreement to its related counterparty, and applied the exemption from the withholding taxation available under the Russia-UK double tax treaty, again on the basis that it paid the royalties for the know-how to its related counterparty. However, the tax authorities looked into the structure of this transaction and insisted that there was no real economic substance to qualify the said operation as royalties payment for the know-how. Next slide, please. And on this basis, they first rejected the deductibility of the corresponding cost for the taxpayer and insisted on application of 15% withholding tax, again claiming that this kind of income is dividends. And why they did so is that they, first of all, they said that the information that was used by the Russian taxpayer is not a know-how, because he already possessed of this information when the agreement was signed. And secondly, they looked into some technical imperfections of the documentation formalizing the flow, again saying that in the transaction with the third party, you would not have gone this way. You should have paid more specific attention to the commercial terms. And also the final key arguments, they said that the financial results of the licensee influence the way the royalty was determined. So practically, the royalties were determined in a manner that allowed the Russian company to maintain some level of operating profit. And we must say that we as tax advisors, simply looking at these arguments, concluded that quite frequently this situation happened not because there is no real know-how behind the flow, but simply because the intergroup flows have their own specificities. For example, there is maybe some true commercial ground why, for example, the Russian taxpayer uses information for free of charge for some period of time, and then they decided to start in charging some royalties when the Russian taxpayer became profit-making. And also, we quite frequently see that the related parties try to conserve some level of operating margin for the Russian taxpayer simply for the transfer pricing purposes. And they reflect these provisions in the agreement, and then the tax authorities come and see that, this is not what we would expect to see with a third-party provider, which is, of course, very worrying signs. And which is why on the next slide we try to summarize some key conditions and key provisions of the know-how arrangements that we suggest paying particular attention to, because, well, again, what we see in practice is the group may be happy with a simple one-page or two-page license agreement, summarizing some key terms within an amicable arrangement. However, we still suggest that these agreements are formulated in a proper way, at least to meet the expectations and the requirements of the tax authorities from this kinds of agreement. And also, although we see that these agreements are frequently governed by the foreign law, we still suggest to see that at least the key provisions and the key conditions under the Russian law are met, that the subject matter of the agreement is properly defined, that the royalties are clearly calculated, and that the agreement provides for the ways that this know-how is used by the Russian taxpayer. And also, the very important topic here is that particular attention should be paid to the way the Russian taxpayer protects the confidential character of the information provided to it, because as we could see on the previous slide and also quite frequently in practice, this is one of the favorite arguments of the Russian tax authorities to say, no, this information is publicly available, or you do not properly protect it, which is why we cannot agree with you that this is a know-how at all. And on this particular block, I would like to step down and give the floor to our commercial expert, Maxim, to say a couple of words on the way this can be justified and protected in Russia.
Yes, thank you. So as Maria said, in order to be licensed as know-how, information should first be protected as know-how. And the key element of key characteristic of know-how is that the owner of know-how takes measures to protect its confidentiality, so that the third parties do not have free access to such information on a legal basis. And such confidentiality can be maintained either by introducing a commercial secrets regime, or, as the civil code says, it can also be ensured by taking other reasonable measures which ensure the confidentiality of such information. Talking about commercial secrets regime, there is a law in Russia on commercial secrets, and Article 10 of this law specifies measures which need to be taken by the owner of information so that such regime is considered to be established. Those measures, you can see them on the slide, they include defining the list of information which constitute commercial secrets. Speaking about commercial secrets, we also mean here know-how, which is protected as commercial secrets. Should also be control over the persons who have gained access to know-how or whom it was transferred or disclosed. There should also be a procedure for handling this information and compliance. Compliance with this procedure should also be monitored by the owner of know-how. There should also be a regulation on how know-how is used by the employees of the owner, which can be done by way of including into employment contracts of those employees relevant provisions on the use of know-how. And finally, if we speak about the business partners of the owner of know-how, then in the contracts with such business partners, the owner should also implement certain provisions which oblige the recipient of know-how to not to disclose it to third parties, to keep it secret, and so on and so forth. And you know that it's a standard practice at the start of any business relationship to conclude an NDA with a business partner, or another option, the confidentiality provisions can be included into the main contract, like a services contract or a 7 purchase agreement. And the final step which needs to be taken if you want to ensure the commercial secrets regime is that you need to label the material carriers of information which constitute commercial secrets. And this is quite formalistic. We know that in other countries it does not exist. Still in Russia we have it. So again, if you take all these steps, just tick the boxes, it's done. You have the commercial secrets regime. But of course, you need to ensure that all this is monitored and complied in practice. As already said, for know-how, we still have other reasonable measures, and Supreme Court has stressed this. It said that the commercial secrets regime is not the only option, so other reasonable measures can also be taken. But what are these measures? It's decided on a case-by-case basis, of course. Surely these measures should give the same effect as a commercial secret regime, so meaning that third parties should not have free access to this information on the legal basis, and the use of information by third parties or employees should be also regulated. And I think we can move to the next slide now, and I give floor again to my colleagues.
Yes, thank you. And we must say that more generally, the Russian taxpayer should also be ready to prove to the Russian tax authorities the economic expediency of this operation, and that it really needs this know-how. So, as usually with the Russian tax authorities, it is not enough for you to really use it in practice. You should also be ready to prove that you really need it and you really get some positive result from it. And on this slide, we also wanted to summarize some key points that we suggest paying attention to when dealing with the know-how arrangements. I will not actually stop on every of it just to save the time of the presentation, but one of these is that we always suggest checking that when we speak about the know-how, such know-how is really recognized as such and is accounted as an IP asset in the books of the licensor. Because what we saw in practice is that sometimes international groups qualify more freely certain valuable information as a know-how. We still suggest reconfirming that this is really an IP and not just some kind of a service being provided. Otherwise, it should be formalized differently. We also suggest paying particular attention to the way you structure the agreement, because what we frequently see in practice is that the group wants to sign a kind of a complex arrangement governing various kinds of IPs, such as trademarks, brands, and also the know-how, and there is no clear distinction between these kinds of IPs. There may also be some additional services, and this is most probably the no-go, because first of all, as such, the know-how is VAT exempt in Russia, and if you want to claim this exemption, it should be separately accounted and separately formalized. But also, what we see in practice is the tax authorities say that, well, when you have such kind of a complex arrangement, and its real substance changes from one year to another, sometimes you do not even know what you are paying for. And how can we agree that your costs are justified if you are paying for some complex of various stuff that you cannot even clearly distinguish and properly count in your books? And I will ask you to hold this thought, actually, because I will come back again to this point when speaking about the intergroup services within the next block. So I think that's enough for the know-how topic. I will give the floor back to Yulia. And next slide, please.
Thanks, Maria. We will continue with another topics for requalification matters. In practice, we see that when Russian tax authorities wants to base their position on requalification, of course, they opted not to perform formalistic and narrowly, and they don't concentrate on the analysis on the specific transaction under consideration to which the tax are related. And in requalification matters, we see that they are trying to put all pieces of the puzzle all together and to see the whole picture. So they first try to get more and more information about not only on the specific transaction, but about another transactions between the entities under discussion. And second, they are trying to collect more information about these entities in general, about their status, about their financial position, about their business goals, and etc. So the first case which demonstrates how requalification could be is the case Воздушные ворота. Here we have a Russian subsidiary which has a Cyprus shareholder. This subsidiary attracted loans from affiliated and not affiliated entities, and one day the subsidiary realized that it has no money to return the loan, and it was decided to assign this loan debt to its Cyprus shareholder. At the same time, on the slide, this is separation 2. At the same time, the shareholder decided to support somehow the subsidiary, and it issued the decision to increase the chartered additional capital of this Russian subsidiary in order to improve its net assets. So it's important to say that decision to increase the capital and debt assignment transaction was formalized purely at the same time. And as a result, since here we have counterclaims, so from this one side, the claim of shareholder to the subsidiary to pay something according to the debt assignment agreement, and from the other side, the counterclaim, the obligation of the parent Cyprus company to make injections to the Russian subsidiaries. So we have two counterclaims, and the parties decided to make an offset agreement. The court, with assistance, of course, of the tax administration, here identified the key arguments. They analyzed the whole scheme altogether, the status of these entities, and they came to the conclusion that from the very beginning, it was obvious that Russian subsidiary is unable to return loan, and it means that transactions 2 and 3 are sham transactions formalized with the only aim to forgive debt for the Russian subsidiary. So, as you may assume, the court ruled in favor of tax authority. Another case that's called the Stankinский молочный комбинат case. Here, we deal with a requalification of advance payments under the supply agreements into other income subject to Russian withholding tax. So what is the history, the essence of the case? We have here the Russian subsidiary who has a lot of affiliated entities in Ukraine and Panama. Russian subsidiary entered into supply agreement with the suppliers in Ukraine and paid the advance payment. These foreign suppliers didn't perform their obligations, and instead they assign the supply agreements to the affiliated entities based in Panama. And so this is affiliated entities who became obliged to deliver goods to the Russian subsidiary or to return advance payments. But nothing happened. There were no supplies. The Russian subsidiary didn't claim for any reimbursement or for any return of advance payment, but instead it continued signing new and new supply contracts with the foreign suppliers. And tax administration within this case, they again scrutinized all the companies involved. They succeeded to prove that the foreign companies based in Ukraine and Panama are zero companies with no staff, with no activity, with no business goals, and etc. And finally, the tax administration succeeded to prove that all the transactions under considerations are sham transactions, and they are formalized with the only aim to transfer money from the Russian subsidiary to the affiliated entity in Panama. So, as you see, the court ruled in favor of the tax authority. Thank you for your attention. I pass words to my colleague Maria, who will continue with the third block.
Yes, thank you. So we decided to finish our presentation today with the most favorite topic of all the taxpayers belonging to international groups, which is the intergroup services and the control over these flows. And frankly, I can almost hear you thinking that not again, but again, because the jokes aside, what we see in practice is that this particular topic is never ever off the agenda of the Russian authorities and us as the tax advisors and legal advisors. And first, we wanted actually to address this topic from a bit of a specific angle that we have recently been working quite a lot on, also together with Maxim and our colleagues from the commercial department, because what we see in practice is that the international groups more and more frequently try and create a sort of the shared services centers in some jurisdictions which may offer not so expensive workforce, and try to transfer the routine functions all around the group to the shared services centers. So this topic is not particularly new, I would say. However, we see that the COVID-19 pandemic and the desire to cut costs actually brought it back to light. And we had quite a number of requests to analyze this possibility for Russia. And we see that it not only serves to the economy, but also the group wishes to bring some more integrity and some more consistency to the way these topics are dealt with around the world. And we are mainly speaking about such type of activities as accounting services, banking function, financial function. And well, unfortunately, we must say that this is not something which may easily be implemented in Russia, and in most of the cases we have to highlight a number of so-called country-specific terms for Russia, which always need to be considered when the group wants to implement this. And this problem, like Rubik's Cube, it needs to be addressed from different sides. So first, there are some legal implications that need to be considered, because what we see in practice that when, for example, the accounting function or the financial function is being transferred abroad, it also implies transfer of some confidential information or personal data, for example, on the employees or the counterparties. And in fact, this binds the Russian company to seek the approval and to seek consent, which may be quite a complicated, not really complicated, but time-consuming work to do. And this is something not everybody thinks about when this idea is being implemented. There are also some other legal requirements that need to be considered. For example, there is a new law that will come into force starting from 2022, which binds the Russian taxpayers to store the accounting databases in Russia. And there are already some explanations saying that this does not necessarily mean that they should be stored only in Russia, but they should at least be copied, meaning that if, for example, the accounting function is somehow exercised abroad, the copy should be stored in Russia, and this again brings some additional administrative tasks to think about. Also, there are, of course, tax implications to consider. The most obvious ones is that the Russian tax authorities could be challenging the deductibility of the corresponding costs for such services, because, of course, when such center is created, it is compensated somehow by all the jurisdictions, including Russia. And the tax authorities in Russia may be asking, like, well, why did you engage somebody from abroad? You could have found someone cheaper and probably even more efficient on the local market, and challenge the corresponding cost follow partner on this basis. Also, we see that sometimes these services are a little bit more complex, and they have some elements of the IP rights use, for example, some apps or programs or databases, which may also be qualified as electronic services, as you probably know, being subject to some specific VAT regulations in Russia. But one of the most important topics here is that when this accounting function is being implemented, and especially during the interim period, there is a high risk of some improper fulfillment. For example, the foreign provider may lose some deadline or file some kind of document improperly. And in this case, the liability issues will anyway take place for the Russian taxpayer. And this is what scares the Russian companies the most when the group tries to impose this kind of the services transfer to them. And next slide, please. Also, this is not only the case for the tax, for some tax underpayments or tax imperfections. This is also frequently the case for the currency control rules, which are sometimes even more strict than the tax ones, and the fines are even higher. And also, what we see in practice is the bank also may ask additional questions and may be reluctant to allow passing certain functions abroad simply because the signatories of all the documents are located in Russia. And another very sensitive topic that we see here is that the local management in Russia is super cautious when it comes to sharing some functions with the group, because they perfectly know that they will continue bearing liability in Russia. And if the tax audit comes and some problems are being found out, the Russian local management are the first ones to answer among the individuals. And there is a broad range of the liabilities that they may face. These are not only monetary fines, but also some non-monetary liability measures, such as, for example, disqualification or some limitations, or even the prison sentence under the worst-case scenario. And also not to speak about the reputational damages, because we had quite a number of negotiations with the Russian local management on these points, and they were saying that, well, we do not want to jeopardize our future career. We know that the market is quite small and everybody knows everyone. So these are points that really need to be considered and need to be negotiated when such kind of initiative is being offered by the group. And this is not to speak about some other practical complexities that also need to be considered and measured in advance, such as, for example, there is a huge amount of translation work that needs to be done unless there are some Russian-speaking in place on the side of the service provider. Also, quite a lot of accounting and tax issues in Russia are being documented by the hard copies, not the electronic documents. And passing these hard copies abroad and back to Russia is quite a complicated task. And also very importantly is that although our, for example, tax legislation is codified, in practice there is a huge number of court cases and explanations and doctrine existing only in Russian that needs to be considered, and sometimes it is even not feasible or not expedient to transfer all this knowledge from Russia to the foreign provider for him to properly do his job and then give back the result. So what we are trying to say is that although this is not prohibited per se, the proper balance should be found each time when such function is being transferred from Russia. And interestingly, what we even frequently see in practice, that when such kind of agreements are being negotiated, there are no longer some amicable intergroup simple arrangements. And in practice, the Russian side, the Russian purchaser of services, asks for more and more legal measures to protect himself in such arrangements, which is why we, again, quite closely work with commercial team and Maxim specifically to elaborate the proper agreement to meet the requirements of both sides if the group chooses to go for this. And I will give the word for to Maxim on this topic, and please move to the next slide.
Yes, as Maria said, there could be certain risks for the service recipient, a Russian company which needs to file the reports and the declarations to the tax authorities if the relevant services which have been provided by a foreign shared service center, they don't meet the Russian law requirements. And as a result, the Russian company itself or its management could be subject to the relevant liability, administrative or sometimes even criminal. Therefore, it's quite important for the service recipient to think about the ways how to protect itself in a contract, in the relevant service agreement for the provisions of such services. So we will discuss several main points which need to be addressed in the contract in this regard. First of all, the proper definition of the scope of services. Should not be just a general phrase that accounting services or tax services, but you need to elaborate a little bit more in the contract. And of course, you need to specify the quality standards which should apply to the delivered services. Sometimes it is possible to refer to the law or to specific legal act which states the relevant quality standards. Secondly, the services acceptance terms. We all know that under Russian law, in the service agreement, the services need to be accepted, and it's common procedure that the parties should sign the service acceptance certificates. What is important is to specify a period of time which is reasonable for the recipient to evaluate the quality of the services, to take a decision, or to write a motivated refusal. So this term for the acceptance should be reasonable, and quite often we also see in the contracts so-called deemed acceptance, when a certain period of time has passed and the recipient doesn't react, and the services are considered to be automatically accepted. In this case, it's quite important that there is no miscommunication in the company of the recipient, so that relevant acts and deliverables are sent to the right person who can take the decision. It can be reached by specifying in the contract that this documentation should be sent to a particular person whose email is stated in the contract itself, for instance. Third point is a warranty period for the services. We should say that it's quite rare in Russia to specify the warranty period for the services. It's more common for the goods. But still it's possible, and if it is provided in the contract, then there is a possibility for the recipient of services to address certain claims regarding the quality after the services have been accepted. Then the liability, which is very important, of course. Liability in Russia, we have damages, which is, apply automatically. Damages are divided into real losses and loss of profit. It is quite common to exclude loss of profit in the Russian contracts. It is also possible and quite market standard practice to limit the real losses that are compensated. Of course, such limitation is more favorable for the contractor, not for the recipient of services. Then we have fines and penalties. Those could also be limited, could be established for a particular breach in the contract, for a general breach of the contract, and there could be a certain percentage, for instance, for a delay in providing the deliverables under the contract, and this percentage could also be kept by like 5%, 10%, or 15%. Separately from the liability, we have indemnity, which we discussed a little bit more on the next slide. And we also have such type of protection for the local management as DO insurance. This is not a contractual point between the parties. This is a separate insurance provided to the management of the Russian company in case there is a liability event for them. Yes, so the indemnity. The indemnity it's a relatively new concept in Russia. It existed many times already in other countries. I think it came from England to United States. It's very common there. But in Russia, it's still not brand new, but a bit new. What is indemnity in Russia? Indemnity means that indemnifying party compensates the financial losses of the indemnified party in case of occurrence of certain events, which should be specified in the indemnity clause. The indemnity clause could be inserted into the contract, or it can exist separately, like a separate indemnity agreement can be concluded. It's very important to list those events which give rise to payment of indemnity, because if you don't list them, the indemnified party will not be able to claim the indemnity. Also, what is important is that it's not a liability in Russia. It's quite a common mistake that we see in practice. The parties mix liability and indemnity in the same clause, so they list everything there: damages, losses, indemnity. In that case, the Supreme Court has stated that if there is any doubt that whether the clause is about liability or indemnity, then it's about liability. So there will be no indemnity applicable. And the amount of the indemnity should also need to be specified. The amount to be paid as indemnity need to be specified in the contract, or alternatively, the parties can specify the method of calculation of such amount in the contract. What is important also in this case is that indemnity clause exists even if it is included into the contract, it exists a little bit separately. So invalidity of the whole contract does not invalidate automatically the indemnity clause, and vice versa. The indemnity clause is considered to be invalid for some reason, the rest of the contract is not affected. And unlike penalties, the courts cannot decrease the amount of the claimed indemnity unless the indemnified person deliberately acts to increase its losses. So I think that's it about indemnity, and we can move to the next slide. I give the floor back to Maria.
Yes, thank you. Since our time is out, I will actually be very quick on the last two slides. Because this summary will be shared with you, and you can come back to us if you have any further questions. We just wanted to highlight that the Russian tax authorities, in terms of several previous months, also try to highlight that they pay particular attention to the topic of the intergroup services, and they organize several meetings with the taxpayers and also with the regional authorities dedicated to this topic that Yulia and myself attended to. And generally, the outcome of this meeting was rather positive, as it is usually the case for the public meetings organized by the tax authorities. So they were speaking that the formalistic approach should be avoided, and that the economic viability should be addressed first, and so on. So all these good thoughts that we all wish could be bottled and opened when the tax authorities come to you with an audit. However, there was one topic on the next slide that I wanted to stop on just for a couple of seconds, where the tax authorities accurately addressed the possibility to use the so-called flat allocation keys under the services arrangements in Russia. So as many of you know, historically, this has always been like a blocking point with the Russian authorities, and it was considered as a sufficient only argument not to allow the deductibility of the costs. And so what the tax authorities say now is that, well, we are ready to think some other approaches here, but maybe you, as the taxpayers, could suggest us how we can address these kinds of reallocated costs based on the allocation keys in terms of the tax audits, because the groups are frequently reluctant to open the information on the ways these costs are actually accumulated on the level of service provider and how are they pushed down to the Russian subsidiary. And we must say that a lot of businesses were concerned by this initiative, saying that, well, they are bringing us into a trap because, the basis of the suggestions that we will share, they may try and conduct the audits in respect to the foreign counterparty, each time digging deeper and deeper till the moment when they want to see the accounting registers, and we all understand that the group will not be willing to do so. And the second problem here is that this may be used as a ground for the regional authorities to address the transfer pricing questions, which are now in the exclusive competence of the Federal Tax Service. So what we would like to say here is that although we might try to express some very cautious hopes that the ice may be breaking on this topic, we will still suggest to wait and see how the practice will go in this domain and what kind of compromise can reasonably be found with the tax inspection. So for the rest, as I said, this presentation will be shared with you. You have the chat box, and my colleagues and I will be happy to stay for some other minutes to answer the questions you may have now. And also, please feel free to contact us. You will have our contact details if you think of some other questions after the presentation. So I think we will go to the questions and answers section. So no questions for now. We see some. It's good to see some people we know among the attendees. So I think we will wait for another minute or so if there are no questions for the moment. So we will be happy to finish the event, and well, as I said, we'll be happy to answer them separately. So okay, I guess the time is out for the moment. So thank you for being with us today, and we hope that you found these topics interesting. And again, we'll be happy to communicate with you on some more specific questions whenever we have them.
Thank you and have a nice day.
Thank you. Have a nice day.